Today we will be talking about the Supreme Court case Carpenter v. United States. In 2011, 4 men were arrested in connection to several armed robberies. One of these men confessed to the crime and gave up his cell phone number, as well as the cell phone numbers of the other men involved in the robberies, which the FBI then used to obtain transactional records for each personal phone numbers.
These records were obtained under the Stored Communications Act, which provides that the government may require telecommunication records when specific and articulable facts show that there are reasonable grounds to believe that the contents of a wire or electronic communications or the records or other information sought are relevant to an ongoing criminal investigation. The transactional records obtained by the government include the date and time of calls and the approximate location of where the calls began and ended based on their connection to cell towers.
Based on the cell site evidence, the government charged Timothy Carpenter, along with other offenses, aiding and abetting a robbery that affected an interstate commerce in violation of the Hobbs Act.
Carpenter moved to suppress the FBI's evidence under grounds that it violated his Fourth Amendment rights, arguing that the FBI needed a warrant based on probable cause to obtain the records.
So the question brought forward to the Supreme Court for this case was, does the warrantless search and seizure of cell phone records, which include the location and movement of cell phone users, violate the Fourth Amendment?
In conclusion, the Supreme Court agreed in a 5-4 decision that the warrantless seizure of Carpenter's cell phone records violated his Fourth Amendment rights.
Chief Justice John Roberts wrote in his majority opinion that the Fourth Amendment protects not only property interests, but also reasonable expectations of privacy. Tracking a person's movement and location through extensive cell site records is more intrusive than past presidents might have anticipated.
Justice Anthony Kennedy filed a dissenting opinion saying that he found that cell site records are no different from the many other kinds of business records the government has a lawful right to obtain by compulsory process.
Justice Clarence Thomas also filed a dissenting opinion emphasizing the property-based approach to the Fourth Amendment questions. In Justice Thomas's view, the case should not turn on whether a search occurred, but whose property was searched. By focusing on this later question, Justice Thomas reasoned that the only logical conclusion would be that information did not belong to Carpenter. Justice Samuel Alito filed a dissenting opinion in which he distinguishes between an actual search and seizure and an order merely requiring a party to look through its own records and produce specified documents, with the former wing far more intrusive than the latter. Justice Alito criticizes the majority party, for which he characterizes as allowing the defendant to object to the search of a third party's property, a departure from the long-standing Fourth Amendment doctrine.